So, the extending of the cases to constitutional cases means all the matters, whether irrespective of its nature, where a certificate is issued by a high court that it involves an important point of law and needs interpretation of the constitution, can be brought before the Supreme Court. That means, in case there is a particular matter brought into the High Court, but the High Court on dealing the case comes to it notices that this particular case needs involvement of constitution, or there is a need of interpretation with the constitution here, and this can be better dealt with the Supreme Court, then it will certify this case that yes, this case can be moved to the Supreme Court. So, this is what called constitutional cases. In case if the High Court refuses to give such a certificate on such a case, then Supreme Court can grant special leave of appeal. Similarly, extending to civil cases, that is in civil matters. For example, case involves a substantial question of law of general importance, or that question needs to be decided by the Supreme Court. So, if the High Court refuses to give a certificate, again the Supreme Court can grant special leave to appeal in suitable cases. And in criminal cases, this extension means there are two types of appeals. In criminal cases, one is cases without the certificate of the High Court, and the second one is cases with the certificate of the High Court. The certificate of the High Court is not required in the following cases, such as when the High Court has reversed the judgment of acquittal given by the lower court and punished the accused with a death sentence, or a case which is withdrawn by the High Court from a subordinate court and sentenced the accused to death. So, in these instances, certificate of the High Court is not required. In all other sorts of criminal cases, High Court certification that the case involves a substantial point of law and interpretation of the Constitution is required for appealing to the Supreme Court. Then we come to this advisory function. Advisory function, the advice means this is advisory, somebody who advises. So, this is like the president can seek Supreme Court's opinion. Right? Now, the Supreme Court has got this advisory jurisdiction on any question of law or fact of public importance as may be referred to it for the consideration by the president. So, the Supreme Court in case if required to express its opinion, then it can do so. This is again done in two classes of matters. For example, number one goes as disputes arising out of pre-constitutional treaties and agreements which are excluded from original jurisdiction by Article 131. And secondly, any question of law may be referred to the Supreme Court if the President considers that the question is of public importance and it is necessary to obtain the opinion of the Supreme Court. Such opinion of the Supreme Court is advisory and not binding on the government, nor is it executable as a judgment of the Supreme Court. So, it doesn't bind the government by its advice. It's just in the form of advisory. Then we have revisory jurisdiction, which is under Article 137 empowered to review any judgment or order made by it with a view to removing any mistake or error that might have crept in the judgment or order. So, in case Supreme Court has given away some particular judgment, but then later it is found that there was some mistake or some error, then this particular thing can be revised. So, this is because Supreme Court is a court of record and all its decisions are of evidentiary value. and they cannot be questioned in any court. So therefore, this goes as the revisory jurisdiction. Then we have judicial review. So the Supreme Court, as I have already mentioned earlier, is the final interpreter of the Constitution. That is, its decision remains final. No one can change once it has interpreted and passed its judgment. So it has the power to review laws passed by the union or state legislatures. In case the union or the state legislatures laws that have been passed are needed to be reviewed, then it can be done. Supreme Court can here declare a particular law as ultra vires or null or void if it goes against the letter and spirit of the Constitution. That is, if it is in some way going against the Constitution. This power is referred to as a power of judicial review, and here minimum number of judges to hear and decide such a case shall be 5. Supreme Court has the power to review all national and state laws and executive orders and declare them null and void if they go against the provisions of the Constitution. For example, presidential order concerning derecognition of the former princes, or say Banking Companies Act of 1969 for the nationalization of 14 banks. Similarly, in August 1999, the Supreme Court held that merit should be sole criterion for admissions to PG and other higher courses in medicine and engineering especially. So such cases can be given a review. Finally, as I said at one point of time, that Supreme Court is a court of record. So what is this court of record? A court of record is a court whose judgments are recorded for evidence and testimony. Now, in a court of law, everything is justified with or on the basis of the evidences. At most, evidences are required in order to justify a case. So the judgments are in the nature of precedents, that is, the high courts and the other courts are bound to give a similar decision in a similar case. They are not to be questioned when they are produced before any subordinate court. Any subordinate court cannot be, they cannot be questioned before any subordinate court. Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Now, this court of record has got two different implications. One, its judgments and orders are all preserved as record. These can be produced in any court as precedents. If a person commits a contempt of court and the court has the authority to punish him, no authority can deprive here the court of this right. So in true sense, Supreme Court acts as the guardian or protector of the Constitution. Now, according to our syllabus, this is all that we need to cover up in this chapter. So, thank you, children.